I could look at the time stamping on the actual cases. I'm not going to do that. That may well have been tampered with ex post facto. This happens sometimes, especially with the Supreme Court of Texas. Cases will be up, then they'll take it offline for a while, and you'll see something new. And if you try to go back and look at something, it may or may not have a slight tweak that I've actually been able to track for the years. But I do know that in June of 2018, I filed a original motion for quo warranto with the Texas Supreme Court, and it was mischaracterized as being connected to an old case I had filed. And my contention was that by the time I ended up resubmitting it and it got put onto the queue, they had intentionally coded it to have the metric it did. The case number is 1H-0600, 600. The 600th case acknowledged for the year 2018. There are apparently right now on the site are reflected two other cases that were filed on the same day I originally filed it, which means that potentially my case could have had one of those case numbers instead, right? And those cases were themselves appeals to the Supreme Court of other cases that had been put in at a lower district court, in a lower court in the state of Texas. Now, I'm not going to go into the details of these cases, but it does kind of seem that this is part of the panning out that has been happening ever since. When I submitted that case, I was living in someplace with a disabled veteran in Fort Worth. I got kicked out, was homeless for a while. Now I'm living someplace where, since I've been here, the management company has changed ownership. And now, presumably, the management company has its office in Las Vegas. Nah. Nothing at all connected. Has nothing to do with the fact that when I was filing that, I was consistently on currents associated with notices regarding the Department of Commerce. No. DOC, nothing having to do with the case about diagnostics. What is this? Medical laboratories doing business as something diagnostics. Nah. Just because of the nature of my case. What was my case? What did I file? What is case 1H-0600? What is the... Not that one? Not that one. In re Charity Colleen Krause. Acknowledged on July 2nd, 2018. But apparently filed on June 29th, 2018. Rejected under another case number that had already been filed and closed, they said. And then I had to reappeal. The problem is there was a weekend in between. And during the weekend in between, there was an article the Saturday after I attempted to submit this that was absolutely 100% directly connected to the charges in this petition. What did it say? What did it say? Statement of case. Krause attempted to file a petition for a leave of information in the nature of a quo warranto 17-0622 with the Texas Supreme Court after her attempts to seek legal redress through a writ of habeas corpus WR-87,139-01 filed with the Texas Court of Criminal Appeals had been used in the commission of acts of fraud connected to an ongoing pattern of racketeering activity. Krause was specifically concerned with the City of Houston's approval of upgrades to its flood mitigation plan after Krause had already attempted to report on an ongoing pattern of racketeering activity connected to the Houston Police Pension Fund and involving misrepresentation of the numbers data for the current City of Houston municipal bond issued by Wells Fargo Bank. The misrepresentation of municipal financial data was concurrent to the use of a legal challenge from the Houston Fire Department by Mayor Sylvester Turner to obscure accurate reporting on the city's municipal bond info and instead used the lawsuit as a derivative. This use of derivatives, including legal filings, was part of the pattern of racketeering activity Krause had been attempting to report and quash since December 2016. This pattern of racketeering activity connected to the abuse of information regarding legal filings was also related to the obstruction of Krause's efforts to report child abuse at a domestic violence shelter in Pasadena, Texas, bridge over troubled waters, that formed the basis of her kidnapping claims and her writ of habeas corpus. The specific pattern of racketeering activity that used Krause for pension fraud involved case law data connected to Boeing Inc. and lawsuits with the state of Texas, as well as other cases connected to the city of Dallas. Krause was unaware at the time of her stay at the bridge over troubled waters that the president of the board of directors was an electrical engineer for Boeing Inc. Krause was, however, aware that children, as well as their parents, were being used while they were staying at the shelter as derivative financial instruments for a number of companies, including companies that were involved with the oil and gas industry, as well as the manufacture of chemicals, and that the daycare center that was on site to attend to the children was designated as the asset of a temporary labor agency down the street. Krause had also attempted to investigate whether or not the cell phone and radio tower located on the property met the necessary specifications for adjacency to a child care center, and was concerned that its proximity to the child care center was a form of human test subject experimentation involving the women and children at the shelter. Section 261.001 Texas Family Code. Such technological considerations would be ones of which individuals employed in weapons manufacturing, the oil and gas industry, chemical manufacturing, and law enforcement, as another member of the board of directors was so associated, would be well aware. Krause was also a witness to how at least 3 mothers at the shelter were coerced into getting medical health assessments or some other form of medical treatment for their children to obtain prescriptions for medications, including psychotropics. The intentional efforts to obstruct Krause's attempts to report on child abuse and instead force her into a 10-day detention for psychiatric treatment observation was. Then there's other allegations. There's other codes cited. But what is the crucial matter here? The day after I attempted to send this in, there was an article in a publication concerning how people that were attempting to assist refugees from other countries that were amassed at the U.S.-Mexico border had put together a database to try to associate family members of people that were being reported as being in detention with people who were in the United States. This was the next day, the day after. I contend that they knew about the intended publication of that article, and they intentionally sabotaged my case being filed the day before the publication of that article so that they could recalibrate it. Why? Because now, instead of tearing to a criticism of a database presumably being used to assist refugees with getting family connections, it tears to a DOJ database regarding gang affiliation. They intentionally did that. They intentionally inserted 2 other cases, one concerning a medical diagnostics company and one concerning a property manager based in Nevada. That's what's tearing now. And the reference points are gang affiliation. Did I say anything that would have been registered on June 29th of 2018 as opposed to when it did end up getting registered, which would have been also registered the same day as those other 2 cases that did not get case number 600? What did I say? Let's see if we can find that. It's just going to take a second. It's not a problem, right? What page are we on here? So let's see here. What did I say? Just a second. Don't worry about it. That Israel is now listed as a, quote, permanent, end quote, funder of public school bonds in Texas, while also being factored into requirements for state contracts impacted by the laws regarding South Sudan and Iran, also needs to be accounted for appropriately. See Pocket Packet for index of Vernon's Texas Legal Codes, Texas Government Code, Volume 14. A Constitution of Texas says that there should be no law, quote, impairing the obligation of contracts, end quote. Section 16, Bill of Rights, Texas Constitution. Not only do these laws directly violate this constitutional duty, but they additionally negate the fact that the Texas Constitution is a contract with the people of the state of Texas. And per the Texas Constitution, there is no law greater than the Bill of Rights. Section 29 Bill of Rights, Texas Constitution. Therefore, the contract that the state of Texas has with the people of Texas is superior to any other potential contract that the state of Texas can engage. According to Justice Brown's opinion in Watson Interest versus City of Jacksonville, sovereign immunity for a municipality can extend no further than to states. As such, actions permitted by municipal officials also reflect on the state. When evaluated from this perspective, then the risks associated with obstructing appropriate reporting on abuses of civil and constitutional rights of the people of Texas, including and especially children, become more poignant. Using immigrant children as competing financial instruments with child citizens of Texas is an abuse of civil and constitutional rights, as well as a breach of contract by the state of Texas with the people of Texas. The precedent set by Texas in addressing issues concerning the use of children and minors as derivative financial instruments for insurance or other purposes is important in addressing other accounting paradigms that are currently under scrutiny on the federal level. The use of parent-child designations regarding accounts for various companies and affiliates provides a specific financial modality through which debt and accrual considerations can be obfuscated. Additionally, just a single derivative can be used for multiple accounts with varying risk assessed to each. So too can parent-child account designations entail varying risk values. That the U.S. military command structure also uses parent-child command designations, and that the move to classify so much public financing debt obligation as emergency assistance that would place recipients of recovery under the purview of the Department of Homeland Security calls into question the distinction between civilian and military sectors in the U.S. society. The U.S. does not practice mandated conscription for military service. Military service is supposed to be voluntary unless there is a wartime draft, and that needs to be announced. Additionally, domestic law enforcement has separate functions than military deployed in foreign countries. The normalization of military command structures portends a serious blurring of lines between civilian society and military operators. Military command structures have a different chain of command and a different system for redress of grievances. There are different social expectations and political obligations of members of the military than civilians. Supporting a domestic policy of separating child commands of immigrants who have not applied through the legal process but are within the borders of the U.S. from parent commands within the U.S. border means something entirely different from this perspective. It is also an issue that was previously put before the state of Texas, as Krause contacted the Texas Veterans Commission on June 6, 2017 and July 3, 2017, both to obtain assistance with reporting child abuse that also included the children of veterans. And then I cite the letter, the name of the letter. Then I go on to say, additionally, the U.S. Constitution prohibits the forced quartering of soldiers. How would using children or others as derivatives in military scenarios impact their ability to obtain assistance otherwise? Amendment 3, Bill of Rights, U.S. Constitution. These child commands are being held in facilities still classified as assets by the Department of Defense, leaving open the possibility that they can be used as military assets via derivative. This is against international law and is completely un-American. That such a decision came as a result of a presidential executive order also calls into question the actual motives behind the executive ban on specific Muslim countries as well as individuals with specific familial relationships. In addition to the parent-child command account structure, many accounting or other databases are relational databases with models that can create trend patterns and analyze or anticipate based on relational designations for, among other things, assessments of projected valuations for financial purposes. The Department of Justice and the Federal Bureau of Investigation already list nearly 30 different databases with information it has gathered over the years, especially since September 11, 2001. That specific classifications of relations to people from Muslim countries should be permitted, but others would not be, compels the question of motive and selection of country and designation of accepted relational assignment. Legal refutations on the ban that seek to justify lifting it based on an inventory of assets available to one without the relational prohibition, such as demonstrated in Hawaii versus Trump, are evidence of this very point. The matter then becomes not so much one of national security as one of financial advantage in controlling associated risk. In essence, high-risk so-called Muslim assets will be permitted to do business in the U.S., but the U.S. absolves itself of responsibility for specific risk classifications for which it would otherwise be responsible. If this is the case, then this would be a violation of the Texas Constitution, Section 7 Bill of Rights, Texas Constitution. This also begs an examination of what high-risk business in the countries from which people were banned was being conducted during the early stages of the ban to determine if there was an intentional effort to prevent legitimate business associates from those countries from being able to access resources from the U.S. in order to give an undue competitive advantage to others who are not from that country. And then it goes on to talk about The question also needs to be asked what, if any, financial advantage was garnered by business colleagues of the president, and if the ban was an abuse of executive privilege in promoting individual private interest over responsibility as chief executive. In accordance with meeting the terms of its contract with the people of Texas, the state of Texas must also assess its responsibility to forego engaging another contract which would violate its requirement to honor its contract with the people of Texas. Accepting the emergency assistance from the Housing and Urban Development Agency with the understanding that it was secured under the terms that violate the constitutional rights of the people of Texas is acknowledging the priority of another contract that is subordinate to the duty of upholding the Bill of Rights. Accepting a contract from the federal government when the federal government is itself engaging in contractual relationships that contravene the Bill of Rights of both the U.S. Constitution as well as the Texas Constitution concerning freedom of religion, as would be the case were the federal government to be found to be using the ban on Muslim countries to accord unfair competitive advantage to non-Muslims, is a breach of contract by the state of Texas with the people of Texas. Section 4 and Section 6 Bill of Rights, Texas Constitution. Now, this was done in 2018. This was done before they intentionally manipulated and recalibrated and recharacterized it in order to use it for acts of fraud. Now we have the situation with COVID-19, and every step of the way, things have been intentionally sabotaged and recharacterized. And rather than bringing charges around what this was connected to, was allegations of a pattern of racketeering activity that was present in the federal budget as had been proposed in 2017, set to take effect in 2018, and how and in what manner Texas was going to respond with an understanding that the same pattern of racketeering was being promulgated in the state of Texas through a specific methodology that was available in case law references and other kinds of manipulations of the legal process as evidenced in a specific codex that is an official legal reference that, among other things, has been cited specifically in terms of its time spatial relevance when it comes to calibration for something like what would be alleged to be a pattern of racketeering activity based upon the year and the specific methodology for that year cited in the actual filing of concern. So now it's 2 years later, and 2 years later, they've implemented numerous completely unconstitutional laws, presumably around contract bidding confidentiality and cases concerning political subdivisions. And what they've done is they've taken other information and completely intentionally twisted it and mischaracterized and misrepresented it. And in the course of that, they tried to present a counter narrative and an alternative narrative in order to try to extort you into agreeing to cooperate with the same criminal activities you were attempting to prosecute previously. This is the essence of extortion. This is exactly what they've been doing. Now, this situation with the COVID-19 relief, the whole year, everything related to the COVID-19 is on another level in terms of the original allegations of a pattern of racketeering activity present in the federal appropriations process at the end of 2017, set to take effect in 2018. And the question was in 2017, as it was in 2018, as it was in 2019, as it still is today, the last day of 2020. Was the process approved in the federal appropriations bill set to take effect for 2018 under the authority of the President of the United States, or was it under the authority of Congress? Because it reveals a pattern of racketeering activity that, among other things, attempts to extort the people of the United States into cooperation with high crimes. Crimes. We're not talking civil restitution. We're not talking about the difference between $600 and $2,000, unless, of course, you're talking about the metric you're hedging on. Did somebody decide they were going to hedge on my 600 because they wanted to what? Get revenge for their wife being raped? Well, I'm sorry. You spent 2 fucking years covering up for rape of children right in front of my fucking face. And what we got right now is we've got some sort of foreign problem because a lot of stuff was set up to be exported abroad. And rather than calling it out for being crime and prosecuting it for being a racket that was presided over by kingpins under the cover of sovereign immunity, you allowed it to get sold after it was trashed and set up to be sabotaged upon re-importation. And now you don't want to reveal that. You don't want to reveal that you intentionally offloaded American assets in a completely fraudulent manner to other countries, hoping to poison the fucking well. And now we gotta swallow the poison pill ourselves. That's what's going on. That's what's fucking going on. I contend, as I did then, it's a pattern of racketeering activity connected to a continuing criminal enterprise. It's a criminal drug enterprise. And every single petition and every single legal challenge that did not get filed in this past year challenging the constitutionality or election interference in the passage of any bill connected to marijuana is also evidence. It's evidence in every single state where a state attorney general refused to file charges